John Dramani Mahama, Mr. Johnson Asidu Nketia. My Lords, is representing the petitioner. Electoral Commission, my Lords, Jim Mensah, Chairperson, representing the first respondent. Mr. Peter McMahon, my Lords, is representing the second respondent.
May it please your Lordships, I appear for the petitioner, and with me my learned friend Tony Litter. May it please my Lords, Justin Amenuvo appears for the first respondent, with me A.A. Somoa Asamoah.
If it pleases your Lordships, I could turn power for the second respondent. My Lords, with me are my learned colleagues Frank Davis, Kweku Esrefi, and Ya Opong.
My Lords, we have before you a motion on notice for an order for production for inspection of documents, in respect of which a request for inspection was served on the first respondent. My Lords, we have this morning been served with affidavits in opposition filed this morning. By both respondents. And I take it that your Lordships are granting them leave to file it out of time. I would have no objection to them asking for leave to file it out of time, just for the record.
Council, it appeared when we were here yesterday, yes, they claimed that they were served just yesterday, I remember. And even some of us had your copy of the motion.
No,
yes,
I don't have a, yes, I'm aware of it. All I'm saying is I will not object. I just wanted for the record for it to be clear that, because your Lordships have in the past indicated that if we do anything that's contrary to your order, We need to that, but we can proceed if your lordships are satisfied.
Oh, yes.
With that.
Let's proceed.
Let us proceed. Let us proceed. My lords, I move in terms of the motion paper and the supporting affidavit. My lords, we filed the request on the 19th of January. And my lords, this is a situation in which, by virtue of Rule 5 of CI 16, we believe that this court essentially adopts CI 47. And therefore, in respect of CI 47, it is Order 21, Rule 9. As we indicate in Exhibit Inspection 2, we filed a search which indicates that there has been no response whatsoever to the request that we made to the first respondents. Now, my lords, there is no question that the first respondent is the person with lawful custody of the documents which we seek to inspect. And it is also quite clear that these documents are public records in the custody of the first respondent. Your lordships will note that each of the categories of documents that we refer to in paragraphs 1 to 5 of the request are originals. Of constituency presidential election results in accordance with the various forms that are required to be exhibited. So what we're asking for are originals of these documents. And in paragraph 6, what we are asking for also has to do with the records of the alleged update to the purported declaration. that alleged update is Exhibit B attached to the witness statement of petitioner's witness 1. Your Lordships will see that the figures in respect of that alleged update including the figures of total valid votes cast are different from the declaration that was made on the 9th of December, and which we have provided evidence of as an attachment to the witness statement of PW1 marked Exhibit A. That is a video recording that your Lordships, that the court saw. And there is, again, no dispute that, for instance, the figure of total valid votes cast in Exhibit B is 13,119,460. Whereas what the petitioner stated, what the first respondent stated, which is attached to the petitioner's witness number 1's witness statement at Exhibit A, what she stated was the figure 13,434,574. 13,434,574. So there is a conflict between those two figures to start with. But that matter is compounded by the fact that in Exhibit B, a figure is mentioned as what the chairperson of the first respondent inadvertently used, which is again different from what the figure that she actually used. The figure that is now contained in this purported correction is 13,433,573. So we have 13,434,574 on the 9th in the declaration as total valid votes cast. Then we have a purported correction, 13,119,460, which purports to correct a figure in the declaration and uses yet another figure, 13,433,573. Now, my lords, the point about all these matters is that these figures are supposed to relate to documents that back the figures. They are supposed to relate to documents in the possession of the first respondent that can justify these numbers. These figures are not supposed to be just plucked out of thin air. They're supposed to be figures based on the backing documents. And your lordships will have noted that in our petition, we indicated that if you actually sum up, if you do the arithmetic in respect of the column where votes are attached to individual candidates, if you do that, the figure that you come to is again a different figure. That is 13,121,111.
Yes. If you sum up in which document?
In our amended petition in paragraph 12. Our amended petition.
You said if you sum up.
If you sum up.
From which table?
That is from what was read. What was
read from the video?
Yes. What was read from the video? Exhibit A.
Exhibit A.
That's right. So we basically listened, took down the numbers, and even though this 13,121,111 did not appear anywhere,
you actually sum up the figures mentioned in Exhibit A,
then
come to
13,121,111.
Thank you.
And we state that in paragraph 12 of the amended petition. So that is a fourth figure. Now, your lordships will note that in the answer of the first respondent that was filed on the 9th of January. In that answer, the first respondent now actually adopts the figure that we had calculated. And for the first time, the first respondent also states 13,121,111 for the total valid votes cast. So the figure that we had calculated becomes now the basis of the answer. The stone which the builders rejected has become the capstone of the answer of the first respondent. My lords, these are the plain circumstances which necessitate a reference back to original documents which are in the custody of the first respondent. So that there be a proper validation of what the correct number is. My lords, we simply cannot have a situation in which, as described by the petitioner's witness number 1, we still, as at today, cannot tell what the correct figures on the basis of which a declaration has been made publicly. We cannot tell what those correct figures are. We simply cannot tell. And my lords, the only way in which ultimately this court is going to have to satisfy itself in our respectful submission is by ascertaining from the first respondent what exactly its chairperson, who is a constitutionally mandated person, is using for her declaration. And your lordships also have before you a witness statement of the first respondent, which is sworn to by the chairperson, Mrs. Jean Adukwe Mensah, and that is filed on the 22nd of January. And there again, my lords, there is now reference made on oath. Well, I'm sorry, it's not yet on oath. It's not yet on oath. I'm crossing a bridge that I have not got to. But the witness statement, which is already before your lordships has this number 13121111, and that witness statement provides no explanation of how in Exhibit B a different number to be corrected is given from the number that we all heard in the declaration. Yes.
Is that not in paragraph 11? Paragraph 11 of the first respondent's witness statements. Is the explanation not there?
My lords, it is not, because, my lords, as I indicated, in the Exhibit B to the witness statement, the number that was given as being corrected is 13433 something something. It is not 13434,574. In the correction that was purported to be made, which I referred your lordships to, and I may go back to it again with your permission, that is the attachment to Johnson Asiedun Ketia's statement, and that is Exhibit B. Your lordships will see that it says the chairperson of the Electoral Commission inadvertently used 13,433,573. That is different from the figure that I alluded to, and that is different from what she's referring to in the paragraph that your lordship has referred me to. So, my lords, the reality of changing numbers is inescapable in this election petition.
Mr. Chikata,
yes.
So these numbers are all related to either the total votes or the total valid votes?
That is correct. And CI 127 tells us how those numbers are supposed to be arrived at. CI 127 regulation 4410 requires an assembling and collation of results from the regions provided by the various regional collation officers as set out in Form 12. So, in the midst of the ever-changing figures, it is our respectful submission that there is a need not only to refer to the originals of what she herself purported to use, so that they can be compared to whatever documentation is available to us from the ground. My lords, there has also been in this case, there has also been extensive cross-examination in respect of Exhibit C, which was struck out, but there was extensive cross-examination in respect of that exhibit, and therefore, my lords, I wish to make reference to that, because the cross-examination purported to show, the cross-examination of counsel for the first respondent purported to show that the two different documents for the Eastern region
My lords, with respect, I never cross-examined on Exhibit C. The exhibit my learned friend might be talking about is Exhibit D, the one that is attached to their letter.
My lords, I do take that correction. It's Exhibit D attached to the letter. Exhibit D. Exhibit D. As in Daniel. There was cross-examination by counsel for the second respondent on Exhibit C, which I will come to later. No, my lord. He cross-examined extensively on it. He did cross-examine on it. But my lord, I was starting with Exhibit D, and I should not have said Exhibit C. Now, my lords, with Exhibit D, counsel cross-examined the witness extensively to show or to explain why one document which has a kind of a stamp, a blue stamp, why that document is different from the other document, and that's where he referred to Ayen Swanu and all that. Now, my lords, without going into all the details of the figures, I mean, it's clear that it was acknowledged that there were differences between those two. So what we are saying respectfully is that in order even to be clear on what was actually used by the first respondent in reaching the numbers that were ultimately totaled, in order to be clear about that, we would request to inspect the original document that she had. It is no response to say that we have both, simply because we have both documents, both what was originally signed even by our agent, and then another document that was not signed by our agent. In terms of the regional summary for Eastern region. So it's no response to say that we have both, because that's precisely the reason why we need to know which one is the authentic one. And the only way to know the authentic one is if we are allowed to inspect. If we're allowed to inspect the originals that are presumably, counsel for the first respondent, who put to the witness certain figures from a certain constituency and all that, has had access to those originals, because otherwise he wouldn't put it to the witness. And counsel is only allowed to put to the witness what he has been instructed by his client. So without question, counsel has information which we are not in possession of simply by virtue of having these two contradictory documents, which are Exhibit D, which are attached to Exhibit D, which are attached to Exhibit D. And, my lords, it was explicit in the testimony that was provided by the second petitioner's witness that the agents of the candidate, the petitioner, had issues with some of these collation sheets and began to air them in the discussions to the relevant officials of the EC, and were awaiting appropriate responses. Now, my lords, as I've said, Exhibit C was also cross-examined upon extensively, and a lot of arithmetic calculations were made in respect of Exhibit C. With different permutations of numbers. And we are saying respectfully that what all that proves is that without knowing the authentic, original documents on the basis of which the chairperson of the first respondent undertook her solemn constitutional responsibility, we are all in the dark. Is there? My lords, we are conscious of the fact that in the election petition in 2012-2013, an application was made in a similar manner for documents to be produced for inspection. And the ruling of the court, which is found in 2013 Supreme Court of Ghana Law Reports at page, the special edition, at page 61 onwards. The ruling of the court states clearly why the lordships on that occasion did not grant the application. And I would respectfully refer to a passage at page 71 of the judgment of the ruling read by Her Ladyship Sophia Adinyira, And she says as follows: in the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which had enabled them to mount this petition on grounds of malpractices in 4,709 polling stations, based on the contents of these duplicate documents in their possession. In that case, the petitioners mounted the petition on the grounds of 24 categories, as they put it, of malpractice in initially 4,709 polling stations. It became 11,000 by virtue of subsequent amendments, 11,000 and more. And so what the court was there saying is that the petitioners themselves have already put forward, in support of their case, documents that they had confidence in. They had put them forward. And therefore, to ask to inspect documents when you yourself have said, we are putting these forward and this is the basis of our case, that is contradictory. In this petition, my lords, we have not put forward results or malpractices in 4,709 polling stations. In this petition, we have put forward the words of the declaration of the chairperson, the returning officer, the only constitutionally mandated body, or person, I should say, not even body, the only constitutionally mandated person to exercise that responsibility. And so clearly, the rationale, the ratio decidendi of that case cannot relate to what we are dealing with in this petition. And her ladyship goes on to say that the affidavit in support of the application does not disclose any need for the inspection and making photocopies of the originals of the documents. My lords, nobody can say that in this case we are not disclosing any need for the inspection. In a situation where we have changing numbers, and in a situation where to this day we are in no place to state a definitive number. In those circumstances, in our respectful submission, it is actually even in the interest of the first respondent, in terms of transparency, in terms of fairness, it is actually in their interest to make available. That is why, frankly, we did not expect that we would have to make this application before that request is granted. We honestly thought that this was something that would be resolved and we would go and have the opportunity to inspect. There are clear provisions in the rules of court within a reasonable time and within reasonable circumstances, and we cannot obviously flout those circumstances. So this is something that could have been resolved, in a very straightforward manner by enabling that inspection to take place without having recourse to orders of the court. But we have not had even the courtesy of an acknowledgement of our request, and therefore we are obliged to seek the orders of the court in order that we can achieve what will enable us to have a fair hearing of the petition that we brought to this court. Now, my Lord, if there's nothing to hide in terms of transparency around these originals, it's difficult to appreciate why an inspection could not have been granted in the course of the last 14 days or so since we filed. 12 days to the end of January, so about 15 days. If there is nothing to hide, I mean, if the interest of the first respondent is transparency, as has been indicated, then why would it be so difficult? Why would it be so difficult to allow access to the originals? We haven't come relying on our duplicates saying that they are the basis of our case. We've come relying on her own declaration. Her own declaration speaks for itself. So, my lords, in this situation, we require access to the originals, which we can then compare with what we have and try to get to the bottom of these ever-changing numbers. Now, my lords, the reference that I made to a fair hearing, my lord, is also anchored because we are saying effectively that this access to these documents is required for a fair hearing in this case, because it is not within the province of the first respondent just to pick and choose numbers from different sheets in the way they sought to do in cross-examining on Exhibit D. It's not within their province just to pick and choose and say, oh, this document which you have, it didn't include Ayenswanu. There's nothing on the face of the document which says Ayenswanu is there or not there. Nothing. And this one which you also have, which is supposedly about the same regional results, regional collation, that document has different numbers. And we just have to take it from them that Ayenswanu's 40,000 is what has led to the difference. Well, that is totally unacceptable, with the greatest respect. And Article 19(13) of the Constitution makes it clear that this court is required to give a fair hearing within a reasonable time. May I just, with your permission, read that article? An adjudicating authority for the determination of the existence or extent of a civil right or obligation shall, subject to the provisions of this Constitution, be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. Now, my lords, as I indicated, we are asking for a fair hearing of the petition that we have brought. And for that fair hearing, we are submitting that the matters that we have, the documents that we have sought access to are necessary documents in order to understand the case that is being put against us, with all its changes and permutations. And so it's our respectful submission. And my lords, I may just make a comment finally on 6. The request in 6, that is not dealing with originals, that is dealing with records of the alleged update to the purported declaration. Now, my lords will observe that that update, Exhibit B to PW1's witness statement, that update is not signed by anybody. It's a press release, and we do know. Okay. Okay. That update is not signed by the chairperson. It is not signed by anybody. And we do know, my lords, that the constitutional role that is assigned to the chairperson, both under the Constitution and under CI 127, that role cannot be delegated either to a media relations officer or to a deputy or any other person. It cannot simply be delegated. And therefore, how the records relating to that alleged update are things that need to be inspected, particularly when we have pointed out to your lordships that in that update itself, certain figures are put there which are different from what we all heard in the declaration. So some records are required, and no doubt there must be some basis internally for the alleged update, and that's the essence of what is in paragraph 6 as distinct from paragraphs 1 to 5. It's our respectful submission, therefore, that in the interests of justice, this application be granted. And I would also just conclude with what is provided in Order 1, Rule 2 of CI 47, that these rules shall be interpreted and applied so as to achieve speedy and effective justice, avoid delays and unnecessary expense, and ensure that as far as possible, all matters in dispute between the parties may be completely, effectively, and finally determined, and multiplicity of proceedings concerning any matters avoided. Indeed, this proceeding, in our view, is really quite unnecessary because it could have been dealt with expeditiously. My lords, I omitted one point in their response that I just want to comment on in one sentence. Both responses begin to raise issues about burden of proof in the case and so on. In our respectful submission, issues of burden of proof are irrelevant to the inspection of documents. The burden of proof in this matter is something on which no doubt we'll have occasion to address on different aspects. Whether the burden of proof is on us to do this or that, those are matters that at the appropriate time we'll deal with. But in their affidavits, essentially, they are laying claim to some view of burden of proof, which is legally very suspect, but on that basis, they are saying that this application should not be granted, and we feel there is absolutely no basis for that.
You refer us to Order 9, 1. Can we take a look at you refer to Order 21, Rule 9. Can we look at Order 21, Rule 11, and if you may address us on it? Since I believe the primary objective of this application is to determine the total valid votes cast. That's the primary objective. Your application, yes, is to determine the total valid votes. No.
We cannot be limited to just the total valid. I'm sorry. Yeah. My lords, this application is not just the determination of the total valid votes cast, because the total valid votes cast goes back to whatever was happening at the regional collation, that is the Form 12 that is referred to, and about which there's been evidence that there was some dispute about that. So it is not just the total, it's also to do with the allocation of the votes. Your Lordship will see that in the Exhibit D attachment that we have, there are differences in the allocations of the votes cast. So it cannot just be in respect of total valid votes cast. It cannot just be.
Can you look at Rule 11? Rule 11, sub Rule 1.
Order 21.
Rule 11.
Rule 11. Production to be ordered only if necessary. Yes, my lord. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. And then 2, where on an application under this order for production of a document for inspection or to the court, privilege from the production is claimed or objection is made to the production on any other ground, the court may inspect the document to decide whether the claim or objection is justified. I don't believe that privilege is an issue here.
Referring to 1.
Yes. And 1, we have addressed you on the necessity. And we have addressed you by referring even simply to the attachment to Exhibit D, which has been the basis of a lot of cross-examination here and the basis of a lot of explanation from counsel. But that Exhibit D itself, in our respectful submission,
our authorities on this point, that it is the court that you make an application to for guidance in this matter. Plus, with respect, if I may refer you to the case of Cogles Ghana Limited number 2 versus Atier number 2, 2003-2004, Supreme Court of Ghana Law Report at page 75. Lord, with respect, Adre JSC, speaking for the court, said this, and with your kind permission, if I may quote it. I hold a view that the application before us cannot be entertained under Rule 5. In my opinion, where a party has difficulty or is in doubt at what steps to take, where there are no express practice of procedure provided, the party must apply to the court for directions rather than, and this is my emphasis, rather than arrogate to himself the powers given to the court under Rule 5.
These are Amenuvo.
Yes, my lord.
You see, he came under mutual discovery. That is Order 21-1. Yeah. Then when you look at the proceedings, we've gone beyond that because there was no response from you. And when you do not, allow inspection or whatever of documents, then you can resort to an application under 21-9.
Yes.
And this is the application you are determining. Yeah. So look at the Cogles case again, whether you can look at Rule 5 of the CI system and apply it to the circumstances.
So my lord, I refer to the Cogles case in order to make the point of the timing of this application.
The time.
Yes, my lords. The timing of this application.
Do you have any time frame after the failure of mutual discovery.
My lords, when you are proceeding...
No. I respond to the question. What I'm saying, that
yes,
beyond mutual discovery, do you have any time frame set down under Order 21?
No, my lord, you have to apply to the court.
Yeah, and this is the application you are determining.
Yes, my lord, also the point is that, with the greatest respect, the point is that where presidential election petition is filed, talks about timeousness, then when you make an application at a particular point in time, in responding to the application, with the greatest respect to the court, we are entitled to make the point as to the timely nature or otherwise of the application. Lord, the second point I wish to make is that the petitioner has failed to prove that the production for inspection by the first respondent is necessary in these circumstances. Lord, this is because the witnesses themselves who came to testify on behalf of the petitioner themselves admit that they have the documents. And Lord, the way this process is that once the document is filled out, or the agents are given the carbonized copies, and we did ask them, both of them, that do you have the documents? They said under oath that we do have the documents. So therefore, if you do have the documents, on what basis is this application being made? My lords, furthermore, it's our submission that the situation is that the petitioner has failed to provide any evidence in support of his petition. And that is why, at the end of the cross-examination of the petitioner's witnesses, this application will be brought in order to give them the opportunity to lead further evidence. I do not believe that it has been the practice of our courts that evidence is led in piecemeal. Evidence cannot be led in piecemeal before the High Court, how much more the Supreme Court. So, my lords, it is our submission that for these grounds, and of course, they bear the burden of proof to provide evidence sufficiently for the burden to shift. They have it, and having failed to do that, they cannot, at this late hour, come and make this application for documents which the witnesses themselves admit are in their possession. That is our submission, my lords.
My Lord, we believe that at the heart of this application is the question of which party bears the burden of persuasion and the burden of producing evidence. Now, my lords, I say so because the petitioner, by the admission of his own witnesses and by law, has photocopies of all carbonized copies of all the processes from the polling station right up to the regional level, and then even to the National Coalition Center. They have copies of all the documents through carbonized copies. Therefore, where the petitioner raises a question about the authenticity of any document, he must first produce what he has. and show that what he has is different from what the other party has. Secondly, if it is in respect of the declaration, the petitioner has all the documents that will enable him sum up the results, the national results of all the candidates. He has the carbonized copies of relevant documents that will enable him sum up the total number of valid votes he got, the total number of valid votes the second respondent got, and the total number of valid votes the other candidates had. My Lord, the petitioner, for reasons best known to himself, has refused to present this before the court when he bears the burden of proof. He has refused to take any steps to meet that burden. He has refused to produce any documents to meet his burden of producing documents. Then he turns round and under this guise of application to produce evidence, he's saying that produce a document. He's trying to garner the evidence that he used to prosecute his case. My Lord, this, with all due respect, is a totally misconceived procedure. My Lord, let me say again that it is not as if the petitioner is saying that from the documents I have, the documents that the EC is producing is not the right document, and therefore we want to see the original, because we have the exact carbonized copy of what the EC has, and what he's producing is different from what we have. He's not saying that. Rather, the application confuses authenticity, because you are questioning the photocopy as not the original, the carbonized copy as not the original. And where the document is authentic, but you are taking issue with the contents, it's a different matter. If the document is authentic and you are taking issue that the contents, you have a problem with it, it's a different matter from saying that it is not authentic. You can only raise the question of authenticity if you have some other document which is showing that this cannot be the authentic document, and say that nobody can quarrel with the petitioner where he says that I have problems with the content of the document. If you have problems with the content of the document, produce the carbonized copies which will show that the contents of the document are wrong. And that is why, my lords, at the heart of this application is an attempt to shift the burden of proof and the burden of producing evidence onto the respondents. And that is never possible in any court of law. My lords, again, we wish to make it very clear that it is not the number of times that counsel refers to transparency that would make his case that things are not transparent. He needs to provide the evidence of lack of transparency, and not just the verbal statement about transparency and repeating it over and over again. Then again, my lords, the petitioner makes a very curious statement about fair hearing. My understanding of his submission is that he's using fair hearing to conjure away the burden of proof. Conjure away. He's using the right to a fair hearing My lords, with all due respect to your lordship, with all due respect to your lordship, I think what I'm saying is appropriate given the context. I'm saying, my lords, with all due respect, that the applications seeks to use the right to fair hearing to conjure away the burden of proof and the burden of persuasion. These are very fundamental issues in a trial process. He cannot shift the burden of proof when he has not led any evidence which compels us to lead evidence in response. He has not adduced any evidence, much more met the burden of proof. That is all the time on him. So, my lord, if this is the reason for his application, my lord, it is a misconceived application. My lords, what makes it worse, my lords, is that he has not met the basic conditions set out in Order 21, Rule 11, 1. 21, Rule 11, 1. 11.1 of CI 47, which reads, with your permission, as follows. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of the opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. My lords, it's our submission that the council has not shown in any way whatsoever the necessity of this application. Furthermore, he has not demonstrated how this will aid the fair disposal of the application or save costs. It will not help save costs because indeed, if the application is granted, it will rather increase the cost of litigation. It will not promote a fair disposal of this this petition because the application is misconceived. Being misconceived, it cannot promote the fair disposal of the cause or matter. My lords, we believe that counsel was right when he referred to the decision in the Supreme Court of Ghana Law Report Special Edition 2013, where at page 70 thereof, the court, speaking through Sofadin JSC, made the following points, and I quote, the guiding principle, page 70, my lords. My lords, counsel was right in the quotation, but he was completely wrong in the gloss and interpretation he sought to put on the text. My lords, I read the text. Quote, the guiding principle in the instant application, which is an application for production of documents or inspection, is whether the order is necessary either to dispose fairly of the cause or matter or to save costs. Now, the court observes the result correlation forms and the declaration forms are public records in the official custody of second respondent, Electoral Commission. The petitioners, as well as the first and third respondent, like all other political parties and independent candidates that contested the December 2012 presidential elections, were given duplicate copies of the same documents through their representatives at the polling and collation centers and so-called strong room of the Electoral Commission in accordance with the provisions of public election regulations. It is our thinking that where a party is already in possession of a copy of a document mentioned in another party's pleading, it is unnecessary to apply or for the court to make an order for the inspection and making copies of the document in question. Then the court makes a very important point. By virtue of the Evidence Act 1975, NRCD 323, Section 166, the duplicate copies of these documents are admissible to the same extent as the originals in the custody of the second respondent, that is the Electoral Commission. Now, the court continues. Petitioners have not raised any concerns about the duplicate copies given them at the collation centers. And they can't raise those concerns because they have not introduced those documents before your lordships. So they cannot raise concerns. So that is why this application is thoroughly unmeritorious and should be dismissed as such.
My lords, may I just, with your leave, I just wanted to indicate in respect of the point. May I, with your leave? Yes, my lords, it's been suggested that we must first produce what we have before we ask for something. There's nothing in Order 21 that...
My lords, that's not what I said. You should not misinterpret me.
That was... And my lords, as far as the carbonized copies being available are concerned, that's exactly the problem. We've indicated with examples that we are confronted with a situation which needs to be clarified.
No, my lords, he can only respond on legal issues. He's introducing facts.
Sit down. Please sit down. You will have...
issues that borders. After many years of undercover investigations, I bring you the seed. Issues that borders many Ghanaians and around the world. The politics.
Fully committed to being fair and impartial.
Current affairs. The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us. The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Muslim community not to have education.
The show is the seed.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 television, beyond the limit.
Allahu Akbar, Allah.
Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Jama'a bayan Allah masu kallon mu, ni ne naku Abu Karim. Alhamdulillah. Lokaci ya kai za mu so makawa muku shirye-shirye a nan television Net2 in Allah ya yarda. Nan muna so mu gane wane ne Allah subhanahu wa ta'ala. Bayan wannan kuma mu gane menene Qur'ani. Bayan wannan kuma muna so mu gane wane ne Annabi Muhammad sallallahu alaihi wasallam. Bayan wannan kuma mun duba yaya za a yi in so yaranmu su gane Qur'ani. Bayan wannan kuma mun kawo muku shani siyasa. Bayan wannan kuma mu kawo muku batun abincin gargajiya na zango, yadda za a yi mu gane zama cikin zango, in so zamantattayyar mu ya yi kyau cikin zango. Ni ne naku Abu Karim. Wassalamu alaikum.
Watch Unauthorized every Wednesday 6 p.m. to 7 p.m. Repeats Thursday 6 p.m. to 7 p.m. only on Net2 TV. Net2 television, beyond the limits.
The economy, politics, sanitation, agriculture, education, join me Monday to Friday as we dialogue on issue-based politics, live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Net2 TV. Net2 television, beyond the limits.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Watch the Presidential Diary this and every Tuesday at 2 p.m. to 2:30 p.m. only on Net2 TV.
Net2 television, beyond the limit.
I want to learn to read and write, to read, to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation. Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn.
Susu, This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Netu TV.
Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limits.
Them in to grant that respect for that. officers of the electoral were made to fill forms for
both respondents. I take it that your lordships are granting them leave to file it out of time. I would have no objection to them asking for leave to file it out of time, just for the record.
Councillor, it appeared when we were here yesterday. Yes, they claimed that they were served just yesterday. I remember. And even some of us had your copy of the motion.
I don't have it. Yes, I'm aware. All I'm saying is that I will not object. I just wanted for the record for it to be clear that because your lordships have in the past indicated that if we do anything that's contrary to your order, we need to. We can proceed. If your lordships are satisfied, let us proceed. Let us proceed. My lords, I move in terms of the motion paper and the supporting affidavit. My lords, we filed the request on the 19th of January. And my lords, this is a situation in which, by virtue of Rule 5 of CI 16, we believe that this court essentially adopts CI 47. And therefore, in respect of CI 47, it is order 21, rule 9. As we indicate in Exhibit Inspection 2, we filed a search which indicates that there has been no response whatsoever to the request that we made to the first respondents. Now, my lords, there is no question that the first respondent is the person with lawful custody of the documents which we seek to inspect. And it is also quite clear that these documents are public records in the custody of the first respondent. Lordships will note that each of the categories of documents that we refer to in paragraphs 1 to 5 of the request are originals. of constituency presidential election results in accordance with the various forms that are required to be exhibited. So what we are asking for are originals of these documents. And in paragraph 6, what we are asking for also has to do with the records of the alleged update to the purported declaration. That alleged update is Exhibit B attached to the witness statement of petitioner's witness 1. Your Lordships will see that the figures in respect of that
is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Netu TV.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Watch the Presidential Diary this and every Tuesday at 2 p.m. to 2:30 p.m. only on Netu TV.
Netu Television, beyond the limit.
After many years of undercover investigations, I bring you the sea. Issues that borders many Ghanaians and around the world. The politics.
Be committed to being fair and impartial.
Current affairs. The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us. The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the zone not to have education.
The show is the sea.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Netu Television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Netu Television, beyond the limit.
In the answer of the first respondent, that was filed on the 9th of January, in that answer, the first respondent now actually adopts the figure that we had calculated, and for the first time, the first respondent also states 13,121,111 for the total valid votes cast. So the figure that we had calculated becomes now the basis of the answer. The stone which the builders rejected has become the capstone of the answer of the first respondent. My lords, these are the plain circumstances which necessitate a reference back to original documents which are in the custody of the first respondent. So that there be a proper validation of what the correct number is. My lords, we simply cannot have a situation in which, as described by the petitioner's witness number 1, we still, as at today, cannot tell what the correct figures on the basis of which a declaration has been made publicly. We cannot tell what those correct figures are. We simply cannot tell. And my lords, the only way in which ultimately this court is going to have to satisfy itself in our respectful submission is by ascertaining from the first respondent what exactly its chairperson, who is a constitutionally mandated person, is using for her declaration. And your lordships also have before you a witness statement of the first respondent, which is sworn to by the chairperson, Mrs. Jean Adukwe Mensah, and that is filed on the 22nd of January. And there again, my lords, there is now reference made on oath. Well, I'm sorry, it's not yet on oath. It's not yet on oath. I'm crossing a bridge that I have not got to. But the witness statement, which is already before your lordships, has this number 13,121,111, and that witness statement provides no explanation of how in Exhibit B, a different number to be corrected is given from the number that we all heard in the declaration. Yes.
Is that not in paragraph 11? Paragraph 11 of the first respondent's witness statements. Is the explanation not there?
My lords, it is not, because, my lords, as I indicated, in the Exhibit B to the witness statement, the number that was given as being corrected is 13433 something something. It is not 13434,574. In the correction that was purported to be made, which I referred your lordships to, and I may go back to it again with your permission. That is the attachment to Johnson Asiedun Ketia's statement, and that is Exhibit B. Your lordships will see that it says the chairperson of the Electoral Commission inadvertently used 13433,573. That is different from the figure that I alluded to, and that is different from what she's referring to in the paragraph that your lordship has referred me to. So, my lords, the reality of changing numbers is inescapable in this election petition.
Mr. Chikata, so these numbers are all related to either the total votes or the total valid votes?
That is correct. And CI
The Ghana Health Service has confirmed 772 new cases of infection of the coronavirus, raising the country's active case count to 5,515. The country has also recorded 8 new deaths relating to the disease since the last update on Sunday, 31st January 2021. bringing the death toll to 424. The new infections are from tests conducted as at 30th January 2021. The update further disclosed that 607 more people have recovered since the last update, bringing the total of clinical recoveries and discharge to 61,843. Currently, 119 of the active cases, it said, were in severe conditions, with 41 in critical condition. These cases are being managed in treatment sites, isolation centers across the country, while some were under home management, the Ghana Health Service said. Ghana has so far recorded a total of 67,782 cases of the virus since it confirmed its first 2 cases in March 2020. Out of the total confirmed cases, 25,603 were from the general surveillance, 41,050 cases from the enhanced contact tracing, while 1,129 have been recorded from international travelers disembarking at the Kotoka International Airport since it was reopened on 1st September 2020, the update stated. A total of 783,432 tests have also been conducted. Out of these, 243,167 are from routine surveillance, 389,159 from contact tracing, and 151,106 from international travelers arriving through the Kotoka International Airport. The possibility rate is 8.7%. Currently, all 16 regions have an active case. The Greater Accra region remains the hotspot for the virus in the country, accounting for more than 50% of active cases, and with a cumulative case count of 39,742. Ashanti region has 884 active cases, while its case count now stands at 12,444. Followed by the Western region with 339 active cases and cumulative cases of 3,563. The Ghana Health Service says only 42% of the Ghanaian population strictly adhere to the wearing of face masks correctly. This is according to a recent survey conducted by the Ghana Health Service. Dr. Patrick Kuma Abuache, the Director General of the Ghana Health Service, while addressing the media on Tuesday, said the survey was conducted in public spaces including lorry parks in some key districts, leading in the number of COVID-19 cases in the Greater Accra region between 7 a.m. and 10 a.m. on January 29, 2021. He said the data showed that 36% of people had face masks but were wearing them inappropriately, while 22% of people were found not in face masks at all. According to Dr. Kuma Abuache, this is good news and his outfit is hopeful that it will continue. The Minister Designate for Information, Mr. Kojo Nkrumah, on his part explained that the reintroduction of a ban on social restrictions, as announced by President Nana Addo Dankwa Akufo-Addo last Sunday, does not include the ban on marriage ceremonies, but rather on social activities including parties and receptions associated with occasions such as funerals and marriage ceremonies.
Kojo Nkrumah, a spokesperson for President Nana Addo Dankwa Akufo-Addo in the 2020 presidential election petition trial, on Tuesday questioned the reasons behind Mr. Robert Joseph Metal Nunu not being used as a witness by the petitioner, John Dramani Mahama. He said Mr. Metal Nunu should have mounted the witness box, take the oath and tell the court that he spoke with Mrs. Jane Mensah, the chairperson of the Electoral Commission, and was instructed to leave the EC strong room. Earlier, Dr. Michael White, the second witness of the petitioner, former President John Dramani Mahama, in a cross-examination, told the Supreme Court that Mrs. Mensah instructed him and Metal Nunu to convey a message to the petitioner and then declared the results on their absence. Mr. Nkrumah said lawyers for the respondents believe that if Metal Nunu had mounted the witness box, the court would have caught him for perjury because he could not take an oath and tell untruth. He said 3 key issues have been settled in their opinions, which were the fallacy that was initially expressed and amplified through Dr. White, that the chairperson of the EC instructed them, adding that it was not just the interchange of words like instruction.
Now, today, 3 key matters have been settled, in our opinion. The first is this fallacy that was being initially expressed and amplified through Dr. Michael Pesa White, that the chairperson of the Electoral Commission instructed the representatives of the petitioner to leave the strong room, and on their blind side, some numbers were put together and announced. We are beginning to see clearly that fallacy, at best, is something that cannot stand cross-examination. When you read the witness statement says, we were asked, check the definition of asked. Now, in the witness box and under oath, he seeks to amend that and escalate the claim by saying they were instructed.
He said, now in the witness box and under oath, the witness seeks to amend that and to escalate the claim that they were instructed, and that was why the lead counsel, Mr. Kuto Ampao, for President Nana Addo Dankwa Akufo-Addo, who is the second respondent, did not take too much time in his cross-examination. He said they were clear in their minds that the fallacy had been settled and the court will take juridical notice, and that it could not even be true that the chairperson of the EC would instruct a representative of a candidate they would obey. Mr. Ponkoma said another matter that sought attention was the Form 13. There was a claim to suggest that the document that was shown to the witness was done through the back door and was not Form 13.
Their witnesses are here making claims of bad faith, which claims are questionable, now raising questions of the venue of the declaration, now suggesting that in one breath they say they never saw the Form 13. In another breath, what is being tendered before the court, they say is not a Form 13.
Is that in all cases in which a court makes an order for discovery, it is a matter of discretion and not as of right. In the ordinary way, where there are issues of facts between the parties, the court will generally make such an order. However, in the instant case, the applicant has not raised any issue that he has no copies of the documents of the subject of this application. In view of the fact that the proceedings so far shows the petitioner has copies of all the documents, the subject of this application, we are of the opinion that no proper case has been made before us to warrant the exercise of our discretion in favor of the applicant. Order 21 Rule 9 of CR 47, which is the basis of this application, should not be read in isolation. It should be read in conjunction with Rule 11 of the said order. It states thus: an order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly the cause or matter or to save cost. End of quote. Furthermore, Section 166 of the Evidence Act, NRCD 323 of 1975, makes it clear that a duplicate of a document is admissible to the same extent as the original unless a genuine question is raised as to authenticity of the original of the duplicate. No issue has been raised against the authenticity of the duplicates in possession of the applicant. The discrepancies which learned counsel for the petitioner has alluded to in his submissions as having occurred in the declaration of 9th December 2020, the press release of 10th December 2020, and the answer and witness statement of the first respondent are issues of evidence and do not give cause for discovery of the documents under consideration. From the above reasons, the application is dismissed.
As the court pleases.
We are grateful to the court.
My lords, we are most grateful.
My lords, there is a matter in respect of a health situation affecting a potential witness, which we have indicated to my learned friends on the other side, we would like to have considered by your lordships in camera, if it is possible, because of the confidentiality concerns. And we would be able to provide some details to your lordships accordingly, if that is permissible to your lordships.
Counsel, did he provide any witness statement on record?
My lord, in fact, the non-provision of a witness statement itself will be explained.
Oh, please, it's a court of record.
Yes, my lord, that is why I said that the circumstances relate to a health situation which have made it impossible to get a witness statement as at now, as we speak. We have been in touch not only with the potential witness, but with his medical, and that's why I said that because of the confidentiality, if you allow us to grant you full information, then you may exercise your discretion as you wish to direct us, and we can proceed accordingly. We're not, if your lordships will not entertain the matter, we will abide by your powers. Let me be clear that what we agreed is that we would put it before you in detail in chambers. We have not, yes, that's it.
Yes, my lord.
Yes, my lords, exactly what the situation is that this morning, learned counsel for the
Don't go to the details.
No, my lord. No, my lords, I was not going to go into any details. I was just going to say exactly what he told us this morning. What he told us this morning was that there's an issue that he wants to raise with the court in chambers. He doesn't want to take us by surprise. So he was just mentioning exactly that there's an issue. That's all.
About the witness?
Yes.
These are
all rise.
document in the possession of the EC because according to Mr. Chachikata, the counsel for the petitioner, the declaration that was made on the 9th of December, those numbers that were put out there, to them, there's a need for those numbers to be looked at again, because to them, according to them, as of now, they are not certain of the exact figures that were used to declare the winner of the election. So they are pleading or praying the court to make available those documents. Right. And then he cited issues like fairness. So he quoted Article 1913 of the 1990 Constitution that in pursuant of fairness, it would be good for the court to allow them to have access to those documents. Then he also talked about the fact that during the 2013 election petition, though JSC Ajinya indicated that the carbon copy of whatever they have is just same as what is there. But the key thing Mr. Chachikata raised was that in that instance, they had come to court with some numbers and some carbon copies, but they have not come to court with any carbon copy because they don't have the figures. So they are praying the court to release those, ask the EC to release those documents to them. Then came in the counsel for the first respondent, Justice Mr. Amanuvo, and he indicated that one, the time. He talked about the time should be, according to him, the time should be within 21 days, or in the 34th day of this trial, and therefore that time has elapsed for them to be asking for this document. Then he also indicated that the argument being put forward by Mr. Chachikata doesn't hold, in the sense that the 2013 one is a clear example. And then came in Mr. Akotoampao, the counsel for the second respondent, also emphasizing that the burden of persuasion, these are the words he used, and burden of proof, lies on the petitioner's counsel, and therefore to him, he used the words, they are trying to conjure away that responsibility, which one of the judges, I think the Chief Justice, drew his attention to, but he insisted that look, what he's trying to say is in line. So with this back and forth argument, the court went to chambers and came back and declared unanimously that what transpired in 2013, and again he will not be able to produce enough evidence to warrant this demand for this document, and therefore
the court also made reference to the fact that the petitioner already has custody of what he is asking for.
Yes. So it says that it doesn't say, use the word, it doesn't warrant the demand for that, because already the carbon copy, and if my memory serves me right, he cited Article 166 of 1975 NRCD that having a carbon copy is as good as the original, and therefore
but again, when the Chief Justice was reading out the ruling on this very particular matter, he also did indicate that in cases where the authenticity of the copy is in question, then you can demand for the originals. In this case, where the petitioner's lawyers not doubting the authenticity of the copies, and that's why probably they were insisting to see the originals.
Yeah, that is the law for you. If we went back to the Chief Justice indicated when reading the ruling, said that look, from the polling station right down to where the collation was done, he had access to all these things, and so he is looking forward to something as a counsel for the petitioner. That is his aim. He has something behind at the back of his mind he wants to pursue.
Already in the possession of the petitioner in terms of the copies, and that until or that the petitioner did not satisfy the court that those documents that are in its possession are not authentic enough, and basically that's what has happened in the court. But even as we speak, the court is meeting the legal counsels in chambers of a matter
that we have yet to confirm exactly what it is, because it's in chambers. As soon as we get the details also, we will let you have it. We'll go back to the studio where our experts are standing by to continue breaking down the issues even further for your understanding.
Your waist, all your body, you make basa.
Thank you so much.
In this continuous fight against corruption. Therefore, the theme, partnering the audit service in protecting the public purse, the role of stakeholders is very appropriate.
Madam Akusiafre Monsel Parry added that as part of efforts to ensure the efficiency and effective delivery of service, management has taken steps to train about 1,000 staff in various aspects of auditing to equip them with the requisite skills needed to improve their proficiency.
I'm reliably informed as part of efforts to ensure efficiency and effective service delivery, management has taken steps to train about 1,000 staff in various aspects of auditing to equip them with the requisite skills needed to improve upon their proficiency. This is another feather in the cap of management, and I duly acknowledge your efforts and commend you on this initiative.
On his part, the acting Auditor General, Mr. Johnson Ikwamwa Asidu, recounted all audit works rendered by the successive Auditors General, which has resulted in significant financial savings in the country.
In the 2020 financial year audits that we are about to launch, a lot of attention will be given to various sources of government revenue, how it is collected, how it is recorded, and subsequently utilized. We shall trace every cedi from its source to where it ends and ensure, in accordance with our mandate, that all public monies have been fully accounted for. The rules and procedures applicable have been sufficient to ensure effective check on the assessment, collection, and proper allocation of the revenue. We also ensure that all public expenditures have been properly authorized and made for the purposes for which they were appropriated.
The audit serves as a key player in the fight against corruption, is mandated by the 1992 Constitution to audit the public accounts and reports to Parliament. Ghana's Information Minister Honorable Kujopo Nkrumah has described NDC's General Secretary, Mr. Johnson Asiedu Nketia, as someone who cannot help save the case of the NDC despite his skillful communication tactics. Addressing the media after Monday's hearing, Kujopo Nkrumah described the election petition filed by the 2020 NDC presidential candidate John Mahama as a bad case. In his view, the lead counsel of the president, Akutu Ampao, during the cross-section examination, exposed the inconsistencies and sometimes outright falsehoods that were peddled by the petitioner and the witness who was in the witness box yesterday.
The first things that counsel on our side sought to do today was to expose the inconsistencies and sometimes outright falsehoods that have been peddled by the petitioner and the witness who was in the witness box today. Our counsel also spent a lot of time exposing the bad faith and prejudice with which the petitioner and his team have approached the work of the Electoral Commission and the chair of the Electoral Commission, ab initio. And that's why you saw them take time to set out right from her appointment, from registration, etc. And the belief on our side that this is just a culmination of the various attempts to undermine an otherwise very good job that has been done. Also exposed through very vigorous cross-examination is a claim that was being made that nobody actually won this election. And that's why you saw the Venerable Akutu Ampao over and over again now raise the numbers and ask the witness to do the computation. And if you fry it, you bake it, you turn it upside down, you cook it, it is still 51% plus for the second respondent and about 47% for the petitioner.
Mr. Nkrumah contended that the NDC, before filing the election petition, took to the streets claiming a stolen verdict. However, when questioned at the Supreme Court, they argued that no candidate of the 2020 election acquired the 50% plus one needed to be declared as the winner. Rating Monday's hearing, Mr. Nkrumah said it was a good day. He further accused Mr. Mahama and the NDC of seeking to undermine the good job of the Electoral Commission and its chairperson, Jean Mensah. Mr. Oponkuma added that the chairperson of the EC had come under constant attacks and vilification since her appointment and have treated all efforts with bad faith and prejudice. Meanwhile, the spokesperson for the petitioner's legal team, Marietta Bru Apiaopong, on her part said the cross-examination rather supports their petition that no candidate won the 2020 election.
We are here challenging the EC on its own figures. Its own figures. What are those figures? There's the 9th of December, there's the 10th of December so-called correction, and there's also the figure in their paragraph 24. And then today we realize that even in some of the constituencies, and they themselves brought out the example, taking on South, there are errors. So if you ask us, what are our own figures? How are we going to get our own figures based on all these flawed sheets and different figures? And so we stand by what we are saying, that based on her own declaration, nobody got more than 50%.
President Nana Dankwa Akufo-Addo has appointed 11 persons as members of the Council of State. They include Nana Otosribo II, Jaben Hene, Archbishop of the Church of Province of West Africa, Justice Osei Akrofi, Mr. Sam Okujetu, Mr. Stanley Benson, Professor Atu Esuman, and Alhaji Aminu Amadu. The others are Dr. Margaret Amwakuhene, Mrs. Georgina Kusi, Mrs. Alberta Kuju, Koro Richard Babini Canton VI, and Alhaji Suli Jeremiah. According to a statement issued by the presidency on Monday, the president, in accordance with Article 89, Section 2, subsection A, I, and III of the Constitution, had also appointed Georgina Theodora Wood, a former Chief Justice, Lieutenant General J.B. Dankwa, a former Chief of Defense Staff of the Armed Forces, and Nana Owusu-Nsia, a former Inspector General of Police, to the Council. Ojianihu Yauchebi II, President of the National House of Chiefs, is an ex-official member of the Council. The composition of the Council will be complete when regional representatives
the economy, politics, sanitation, agriculture, education, join me Monday to Friday as we dialogue on issue-based politics, live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Netu TV. Netu Television, Young Talent.
After many years of undercover investigations, I bring you the seed. Issues that borders many Ghanaians and around the world. The politics.
Committed to being fair and impartial.
Current affairs. The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us. The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the community not to have education.
The show is this.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 television, beyond the limits.
After many years of undercover investigations, I bring you the sea. Issues that borders many Ghanaians and around the world. The politics.
Committed to being fair and impartial.
Current affairs. The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us. The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Muslim not to have education.
The show is the
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 television, beyond the limits.
Learning to read, reading to learn, learning to read, reading to learn. Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation. Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn. Susu. This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Net2 TV.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Watch the Presidential Diary this and every Tuesday at 2 p.m. to 2:30 p.m. only on Net2 TV.
Learning to read, reading to learn, learning to read, reading to learn. Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation. Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn. Susu. This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Net2 TV.